Welcome to the Disability Approval Path.
Welcome to Social Insecurity and Disability, the Approval Path with Deborah Spector, lead attorney and managing partner at Spector & Lenz, and a veteran advocate for clients navigating SSDI and SSI claims. I'm Evan Mack, and in today's episode, we're talking about the next steps if your application has been denied and what you can do to turn things around. This is what to do if your Social Security disability claim is denied. Welcome back, Ms. Deborah.
Thank you. Good to see you again, Evan.
Good to be seen. Good to see you.
Yeah.
All right. So right off the bat, Ms. Deborah, how common is it to be denied benefits the first time you apply?
It is so common, Evan. So
Wow.
people often get their information about this from neighbors, mothers-in-law, things they read on the internet.
Mm-hmm.
So I'll tell you what I consider reliable. First of all, the denial rates are fluid. They change, from day to day, minute to minute. But generally, we tell people on an initial claim, 60 to 70% of claims will be denied. That's a lot.
Wow.
2 out of 3 will be denied. And it's not because the government is punitive in any way. It's because they're looking for, I tell people, think of it as a big sieve. They're looking for the cases that are easy, clear-cut, not subjective cases of disability. So in that 30, 35, 40% who do get approved, we have really the tragedies. We have terminal cancers. We have loss of 2 limbs. We have people who are bedridden, wheelchair-bound. They get approved initially, or they should. Everybody else, where there's a more subjective question about the extent of disability, how bad is the pain? How much can you lift? Those cases will be denied on the first round.
So what are the most frequent reasons people do get denied? Is it just because their cases aren't as extreme as the one you were mentioning?
Well, yeah, and their conditions are not found on the list of impairments. So at the risk of boring you, I'm going to tell you one more time the 5 steps that Social Security goes through, the analytical approach to these cases. Question 1, are you working? Well, if you're working, you're going to be denied. We have some things we can argue about whether it's really work, whether it's subsidized, but you're going to be denied. Question 2, do you have a severe impairment? Now, not only do you have to have an impairment that affects a basic work function, but it has to be medically documented, and it has to last for a minimum of 12 months. It can be retroactive or prospective or a combination, but something like, a broken wrist will be denied because it's not going to last. It should heal up. You should be okay. Now, this also applies to things like breast cancer, strokes, things that should resolve within 12 months. Those cases will be denied, even though after 12 months, people may still have what are called sequelae, consequences from these conditions that inhibit their ability to work. Next place where cases are denied is at step 4 of that evaluation, where, if you remember, we said, what's your residual capacity? How does it compare to your past work? If it matches up, you'll be denied. They'll say, hey, you can do your past work, whether the job's available or not. And then most cases we deal with are denied at step 5. Step 5 is where you've shown that you can't return to your past work. Not that the job isn't available, but that you don't have the capacity for it anymore. That you can't do your past work, and they'll say, great, there's something else you can do, less demanding. So at any of those levels, you could be denied. I would say most of the cases we see are denied at step 5.
But Deborah, you said they deny people for strokes though? Like that seems pretty extreme, especially, you know what I mean? Because strokes have there's a spectrum. What if it's like a severe stroke? Because that kind of does limit your capacity to work or even function.
Sure, but if you're familiar with stroke patients, if it's not massive, and the individual's bedridden forever, but for most strokes, there's going to be an initial acute period. There'll be some resolution, there'll be some therapy, and over time, things get better. Now, a guy who was a carpenter, who has a stroke, may not be able to return to work as a carpenter, lifting wood, lifting nails, hammering, carrying power equipment. But if he's 50 years old and can sit at a desk, the government may say there's something else you can do.
Wow.
That's arduous. Same thing with breast cancer. Thank God, most of the breast cancer cases these days are found, treated, resolved, and women get on with their lives. They may have a period of interruption for a few
Right.
months, but not a year. Um, Similarly, bladder cancers, very treatable. Those are often not disabling for a year. Or I like to use the example of the broken bone. If you
Mhm.
break your wrist, if I fall on the ice and I break my wrist, that should be resolved within 6 to 8 weeks. It
Right.
might take me out of work, but it's not a disability under the government's rules.
Mm.
However, if I break the big bone in my thigh and it's a complex break and it requires hardware, and I was a carpenter or a carpet layer, 58 years old, and that thing then develops some complications, maybe some arthritis, that might be enough to take me out of commission for a year, but that case will still not be approved initially.
Wow. So what should someone do right away if they receive this denial letter?
Oh, appeal, appeal, appeal. If, unless you're better and you've returned to work or feel that you could soon, you should appeal. Now, the appeal deadlines are really important. Most appeals, with a couple of exceptions, are due within 60 days of receipt of the denial notice.
Mhm.
So that actually in real time means 65 days from the date of the letter because they build in a 5-day mailing period and say, we're going to assume you get this within 5 days of the date of the letter. You appeal. Appeals most easily are done online. Social Security has just a wonderful website and they have great links. And you can go on the link, file your appeal, and at least stop the clock from running while you
Mm.
figure out how you're going to prove up your appeal. So if you're denied initially, 60 days to appeal. If you're denied on reconsideration, 60 days to appeal and request a hearing. If you're denied after the hearing, 60 days after the judge denies the case. And if you're denied by the appeals council, you have 60 days to file a lawsuit in federal court. So 60, 60, 60, 60, except if you're receiving benefits and the government cuts you off because they say, hey, we think you've improved, that you could go back to work. If you appeal within 10 days of receipt of the notice, and if you affirmatively ask, your benefits will continue until you get a hearing.
Mm. Can
So
can you
that's the
explain
10-day rule.
can you explain that request for reconsideration? How does that work?
Okay, so initial denial, the first appeal is a reconsideration, and that's
Okay.
exactly what it means. They're not going to they're going to reconsider the initial decision, and
Mhm.
those are denied like 85, 90% of the time. They're kind
Wow.
of a rubber stamp. What they're looking for at reconsideration is something like, oh gosh, are we working this guy up for a stroke, but he really has liver disease, and that's what disables him? Did we make a gross mistake? Those are the cases resolved at reconsideration, and others when there's additional important medical evidence that's submitted. The initial claim and the reconsideration are handled in the state agency of your state in
Mm.
almost every state. I'm in Illinois. The cases are handled in Springfield, which is our state capital,
Right.
where state employees who work for the state government but under contract to the federal government, they're called adjudicators. They gather the evidence, they send out the forms, they analyze the case, they make the decision, then they tell Social Security what decision to issue to the client. And on reconsideration, it loops back through that office again. A different individual, but the same office. It goes back to Springfield. That's the reconsideration. And it really is appropriately named. It's just a reconsideration.
Mm.
If you're denied reconsideration, the next step is a request for hearing before an administrative law judge.
Okay.
Again, that can be done electronically through a link on the website. And in that case, it's quite a bit different. At that
Mm.
level, your case is assigned to an administrative law judge, usually closer to where you live. So, for example, in Illinois, where we are, most of the cases are heard at different offices in the Chicago area. But they're done these days by phone and video most of the time. So we could have a judge in St. Louis hearing a Chicago client. At
Wow.
that level, things are different. At that level, the judge is making what we call a de novo, a fresh decision about whether or not you're disabled, considering all the evidence in the file, including what the state said before when they
Mm.
denied you. A little hearing is conducted. It's called an administrative hearing. It's not like court in other areas. It's not like traffic court and it's not like federal court. It's a little administrative hearing. And because of COVID, they're mostly done the way you and I are having this
Wow,
interview, which has really changed the ballgame.
it's
It's
incredible.
less stressful for our clients, it's more conversational, and it's more efficient. And people don't have to go and sit in hearing offices in the waiting rooms all day. So
Yeah,
this is
that's ideal.
all right. The judge at the hearing questions the claimant, questions any witnesses the judge may be calling, usually vocational witnesses, occasionally medical witnesses, might listen to anyone else who has evidence to submit, and then reviews the entire, what we call the documentary, the written record, and issues a decision. Now, nationally, again, it changes day by day, but
Right.
nationally, the judges approve more than 50% of the cases that come before them. But if you think about this, the pyramid of cases that are going up to that level is getting smaller and smaller.
Mm,
There's a big denial base, and only some people decide to file an appeal. And of the group that's denied, only some people go up to the hearing level. So it's a smaller pool. And about half of those or more nationally are approved by the judges.
do you think people, oh, so go ahead, say it again.
Well, next step after that is like a paper review, and it's
Right.
done in Baltimore by a board of judges called the Appeals Council, and they have a very low reversal rate,
Well,
back
Ms.
down to
Deborah,
10%.
do you feel like a lot of people get denied because they maybe fatigue, maybe they don't feel like fighting or doing reconsideration or refiling or appealing? Do you feel that's how a lot of things get claimed because people kind of just stop pursuing?
Totally, totally. Except we never know, do we? Do people give up because it's an arduous, long process? Do people give up because the process is so difficult and appears that it may not be helpful? Do they give up because they really are able to work and get a letter saying, we don't think you're disabled.
Mm.
We think there's other work you might do. And they think, maybe there is.
Mm,
Maybe even though I used to work in a warehouse pulling boxes off a shelf, maybe I could get a job in a doctor's office answering the phone. Maybe I could handle that. So we have the group that gives up because it's such an awful process. We have the group that could go back to work. So we never know. Are we, as each step goes up, are we dealing with the most disabled or, frankly, the most capable? Those
mm,
who are able to navigate the system, if they need it, get help doing it. So, a great question. I think it's a mixed bag, and those are just my impressions. Probably a bit of both.
right, right.
Yeah.
Do you need a lawyer at the appeal stage, or can you handle that alone?
Okay. So, theoretically, in our judicial system, you don't need a lawyer to do anything,
Hmm.
right? You can go to the Court of Appeals, you can go to traffic court, you can go to criminal court
Yeah.
on a felony charge. You can do anything you want without a lawyer. So the question becomes, do you want to get professional help?
Hmm.
And that's a different question than do you need a lawyer?
Right,
People often say to me, is it better if I hire a lawyer? And I say, you know what? This is our practice. This is what we do. So
right.
I'm not going to say that to you. What I will tell you is what a lawyer or other capable representative can do for you. And then you make your own decision about whether you need a lawyer or not. So, first of all, non lawyers can appear as representatives for people and do. Sometimes they're, for example, people from the VFW
Mm,
who have done a lot of this might appear with a veteran, or there are paralegals who've been certified and they will appear with an individual. And there are paralegals who are not certified who will appear. So it's a mixed bag, but I'm going to talk about lawyers. And I feel strongly that people who are trained should represent people, not any lawyer, not the lawyer who's handling your workers' comp case and who says, oh, hey, no problem, I'll take care of this for you too, and may
right.
know nothing about this very complex system. Now, the stats show that if you have a lawyer at the hearing, you're more likely to be approved. I have not seen stats for initial and reconsideration claims, and I always tell people if you file a claim through our office, through another lawyer's office, or a reconsideration, I could not, with a straight face and ethically, say you're more likely to be approved. But what I will say is you're more likely to have a complete claim. You're more likely to know what needs to be submitted, what's
Right.
relevant, what's not relevant, how it's going to be evaluated. Because what this is in practice is quite different from what it feels like it should be, in your gut.
Yeah. Yeah.
Like, hey, my auntie's disabled. What's the problem? Well,
Yeah.
it's not how it works, right?
Yeah.
Okay.
But what role does additional medical evidence play in a successful appeal? Just keeping records in general.
Oh, it's huge. It's huge.
Right.
So these cases turn on medical evidence. As I was preparing for this meeting, I was thinking about years ago a client who said to me, I have ankylosing spondylitis. It's a terrible inflammatory condition.
Wow.
And I thought, okay. And then as the case developed, the medical records would show history of ankylosing spondylitis, but there was no testing. There was nothing to prove it. There was no doctor diagnosing it. They were just,
Wow.
how medical records work. They just pick up
Yeah.
the last record in the history. Well, it turned out in the end, this individual didn't have ankylosing spondylitis. Probably what happened was a doctor once said to him, maybe this is ankylosing spondylitis. And then every doctor after that was told, that's what I have.
Yep.
Well, that is not medical evidence. Medical evidence, clinical signs, clinical findings, laboratory reports, imaging, including X-ray, MRI, CT scan, PET scan. These cases require medical evidence. Now, it's not a volume matter. The more pages you have, the more likely you're to be approved. No. But the more quality medical evidence you have that directly links to your symptoms and thus to your limitations, that's what the case is about.
Mm.
And then if everything is done properly, by the time you get to the hearing, the testimony should be the icing on the cake. The
Okay.
case should have been made. Let me add this. In our cases, we also, over the years, use and continue to use personal statements. So I tell my client, sit down, page and a half, no more than 2.5 pages. I want your life. Tell me, I was in good health and I was whatever, up until 2012. And this is what happened. I'm not asking you to play doctor. Just tell me about your life since then with a focus on limitations, because that's what this is about. Medical evidence that leads to symptoms that lead to functional limitations that preclude work.
Wow. But Miss Deborah, what if you miss the appeal deadline though? What is there anything you can do, or is that pretty much it?
Sure. No, there are a lot of things you can do. Case by case, so it depends on a number of factors. But generally, you can ask the government for good cause to file a late appeal. The classic good cause is my house burned down, I didn't get the notice, or I moved, it went to my old address, or I was hospitalized and I couldn't file the appeal on time. If you ask for good cause, they're very, very liberal about letting you file a late appeal. Now, you can't do that 2 years later, right? But if you miss it by a few weeks, whatever, they're very lenient about that. So you can request good cause for a late appeal. You can file again, depending on the circumstances. In some not rare, but uncommon situations, you can't really file again. But generally, you can file again. And we tell people, ask to reopen the previous decision. And there are regulations that permit reopening a decision. It's discretionary, which means you don't have a right to reopen. It's not given to you as a matter of right under the rules. It's within the government's discretion. And there are certain rules that apply to it. Appealing is a matter of right, though. You have a right to have this case heard. Reconsideration, hearing before a judge, appeals counsel in Baltimore, and if you choose to, a federal district judge in your local federal courthouse.
So is there hope for people who have already been denied once or even multiple times? What can you tell the people at home if they're listening?
Well, first of all, I usually don't talk to people who haven't been denied once or
Okay.
more than once. That's when they go looking for lawyers, right? So many people approach this process And I'll give you an example of a client whose kid's case we just won. And she went, it's a kid with on the spectrum, autism spectrum disorder, who works very part-time at the local community college, and he's a janitor. He works in maintenance. He has very limited, regular functions, supervised, that he can do, so he makes a little bit of money. Mom got him on what's called SSI, the welfare program, a few years ago. Now he's been working. So now he's what we call an insured worker. He's been paying into the Social Security system. So mom thought, well, I'll apply for disability insurance for him instead of, or in addition to the SSI. And I'll explain another time how that's calculated.
Right.
And it should be a no-brainer, right?
Right.
They already know the kid's disabled. They're already paying him a check every month. So mom goes and she figures, no problem. Applies, gets denied. Most people do. Even in a situation like this, goes to reconsideration, denied, requests the hearing and thinks, no brainer.
Right.
I'll go in and explain to the judge, my kid's already disabled according to the government. Could you just approve this additional program? Well, the judge went nuts and said, I don't think your kid's disabled at all. And I might try to take away whatever.
Wow.
And so things happen. But up until that point, the mom, as a layperson, smart, capable layperson, logically thought, I can handle this. I don't need a lawyer. Came to us at that point after the judge had denied her, and we had to file suit in federal court after the appeals council. So people usually don't come to us until they realize I might need a lawyer.
Right.
Now that can happen initially. We are referred a lot of cases by workers' compensation attorneys who are working on a case, guy's badly injured, the radar goes off and they think, wow, he could be entitled to disability as well as work comp. And they'll have him contact us. And we'll say to the guy, you know what? Here's the link. You can file this claim yourself. If you'd like us to file it for you, here's how that works. Or personal injury lawyers or estate planning attorneys. So we do get a lot of initial claims. And sometimes people want to get a rep to file a claim. Sometimes they'll say, you know what, I'm going to file it myself. Thanks for the information. I'll get back to you if I'm denied. And as I just explained, statistically, they're going to be denied. So whatever. I'm always happy just to talk to people, explain the process, say this is how it works, and then make your own decisions.
Miss Deborah, thank you so much.
You bet.
Awesome. If you've been denied, you're not alone and you're not out of options. Social Insecurity and Disability, the approval path is here to guide you. Connect with Ms. Deborah at spectorandlens.com and be sure to like, subscribe, leave a review if you found this information helpful. Thank you so much for joining us.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.